We will hear argument this morning in case number 11398, Department of Health and Human Services versus Florida. Mr. Long?
Mr. Chief Justice, and may it please the Court, the Anti-Injunction Act imposes a pay-first, litigate-later rule that is central to federal tax assessment and collection. The Act applies to essentially every tax penalty in the Internal Revenue Code. There is no reason to think that Congress made a special exception for the penalty imposed by Section 5000A. On the contrary, there are three reasons to conclude that the Anti-Injunction Act applies here. First, Congress directed that the Section 5000A penalty shall be assessed and collected in the same manner as taxes. Second, Congress provided that penalties are included in taxes for assessment purposes. And third, the Section 5000A penalty bears the key indicia of a tax. Congress directed that the Section 5000A penalty shall be assessed and collected in the same manner as taxes. That directive triggers the Anti-Injunction Act, which provides that no suit for the purpose of restraining the assessment or collection of any tax may be maintained in any court by any person.
Well, that depends, as the government points out, on whether that directive is a directive to the Secretary of the Treasury as to how he goes about getting this penalty, or rather a directive to him and to the courts. All of the other directives there seem to me to be addressed to the Secretary. Why should this one be directed to the courts? When you say in the same manner, he goes about doing it in the same manner, but the courts simply accept that manner of proceeding, but nonetheless adjudicate the cases.
Well, I think I have a three-part answer to that, Justice Scalia. First, the text does not say that the Secretary shall assess and collect taxes in the same manner. It just says that it shall be assessed in the same manner as a tax, without addressing any party particularly.
Well, he's assessing and collecting it in the same manner as a tax.
Well, the assessment, the other two parts of the answer are, as a practical matter, I don't think there's any dispute in this case that if the Anti-Injunction Act does not apply, this penalty, the Section 5000A penalty, will, as a practical matter, be assessed and collected in a very different manner from other taxes and other tax penalties. There are three main differences. First, when the Anti-Injunction Act applies, you have to pay the tax or the penalty first and then litigate later to get it back with interest. Second, you have to exhaust administrative remedies. Even after you pay the tax, you can't immediately go to court. You have to go to the Secretary and give the Secretary at least 6 months to see if the matter can be resolved administratively. And third, even in the very carefully defined situations in which Congress has permitted a challenge to a tax or a penalty before it's paid, the Secretary has to make the first move. The taxpayer is never allowed to rush into court before the Secretary sends a notice of deficiency to start the process. Now, if the Anti-Injunction Act does not apply here, none of those rules apply. And that's not just for this case. It will be for every challenge to a Section 5000A penalty going forward. The taxpayer will be able to go to court at any time without exhausting administrative remedies. There will be none of the limitations that apply in terms of you have to wait for the Secretary to make the...
Why will the administrative remedies rule not be applicable? Exhaustion rule not be applicable?
Well, because if the Anti-Injunction Act doesn't apply, there's no prohibition on courts restraining the assessment or collection of this penalty, and you can simply...
Well, but courts apply the exhaustion rule. I mean, I know you've studied this. I'm just not following it. Why couldn't the court say, well, you haven't exhausted your remedies, no injunction?
Well, you could do that, I think, as a matter of common law or a judicially imposed doctrine, but in the code itself, which is all, I mean, the Anti-Injunction Act is an absolutely central statute to litigation about taxes. And the code says, first it says you must pay the tax first and then litigate. So that's the baseline. And then in addition it says you must, I mean, it's not common law, it's in the code, you must apply for a refund. You must wait at least 6 months. I mean, many of these provisions are extremely specific, with very specific time.
But they would apply even if the rule is not jurisdictional. The only difference would be that the court could enforce it or not enforce it in particular cases, which brings me to the Davis case, which I think is your biggest hurdle. It's a case quite similar to this, in which the constitutionality of the Social Security Act was at issue, and the government waived its right to insist upon the application of this act. Of course, if it's jurisdictional, you can't waive it. So are you asking us to overrule the Davis case?
Well, Helvering v. Davis was decided during a period when this court interpreted the Anti-Injunction Act as simply codifying the pre-statutory equitable principles that usually, but not always, prohibited a court from enjoining the assessment or collection of taxes. So that understanding, which is what was the basis for the Helvering v. Davis decision, was rejected by the court in Williams Packing and a series of subsequent cases, Bob Jones. And so I would say, effectively, the Davis case has been overruled by subsequent decisions of this court.
Mr. Long, why don't we simply follow the statutory language? I know that you've argued that the Davis case has been overtaken by later cases, but the language of the Anti-Injunction Act is no suit shall be maintained. It's remarkably similar to the language that was at issue in Reed Elsevier. No civil action for infringement shall be instituted. And that formulation, no suit may be maintained, contrasts with the Tax Injunction Act. It says the district court shall not enjoin. That Tax Injunction Act is the same pattern as 2283, which says courts of the United States may not stay a proceeding in state court. So both of those formulas, the TIA and the no injunction against proceedings in state court, are directed to court. The Anti-Injunction Act, like the statute at issue in Reed Elsevier, says no suit shall be maintained, and it has been argued that that is suitor-directed in contrast to court-directed.
Right. Well, I mean, this court has said several times that the Tax Injunction Act was based on the Anti-Injunction Act. You're quite right. The language is different, but we submit that the Anti-Injunction Act itself, by saying that no suit shall be maintained, is addressed to courts as well as litigants. I mean, after all, a case cannot go from beginning to end without the active cooperation of the court.
But how is that different from no civil action for infringement shall be instituted, maintained and instituted? Anything turn on that?
Well, perhaps a party could initiate an action without the active cooperation of the court, but to maintain it from beginning to end, again, requires the court's cooperation. And even if the court were inclined to say as an initial matter, if this statute were coming before us for the first time today, given all of your recent decisions on jurisdiction, that you might be inclined to say this is not a jurisdictional statute. A lot of water has gone over the dam here. The court has said multiple times that this is a jurisdictional statute. Congress has not disturbed those decisions.
Well, the court has said that many times, but is there any case in which the result would have been different if the Anti-Injunction Act were not viewed as jurisdictional, but instead were viewed as a mandatory claims processing rule? There's
certainly a number of cases where the court dismissed, saying it is jurisdictional. As I read the cases, I don't think any of them would necessarily have come out differently, because I don't think we had a case where the argument was, well, the government has waived this, so, even if it's not jurisdictional.
Well, the clearest way of distinguishing between a jurisdictional provision and a mandatory claims processing rule is whether it can be waived and whether the court feels that it has an obligation to raise the issue sua sponte. Now, if there are a lot of cases that call it jurisdictional, but none of them would have come out differently if the Anti-Injunction Act were simply a mandatory claims processing rule, you have that on one side. And on the other side, you have Davis, where the court accepted a waiver by the Solicitor General, the Sunshine Anthracite coal case, where there also was a waiver, and there's the Williams Packing case, which is somewhat hard to understand as viewing the Anti-Injunction Act as a jurisdictional provision. The court said that there could be a suit if there's no way the government could win and the plaintiff would suffer irreparable harm. Now, doesn't that sound like an equitable exception to the Anti-Injunction Act?
No, I think the best interpretation of the court's cases is that it was interpreting a jurisdictional statute, and indeed in Williams Packing, the court said it was a jurisdictional statute. But again, even if you had doubt about simply the cases, there's more than that, because Congress has not only not disturbed this court's decision stating that the statute is jurisdictional, they've passed numerous amendments to this Anti-Injunction Act.
Well, it seems you can't separate those 2 points. The idea that Congress has acquiesced in what we have said only helps you if what we have said is fairly consistent. And you yourself point out in the brief that we've kind of gone back and forth in whether this is a jurisdictional provision or not. So even if Congress acquiesced in it, I'm not sure what they acquiesced in.
Well, what you have said, Mr. Chief Justice, has been absolutely consistent for 50 years since the Williams Packing case. The period of inconsistency was after the first 50 years, since the statute was enacted in 1867. And there was a period, as I said, when the court was allowing extraordinary circumstances exceptions and equitable exceptions, but then very quickly it cut back on that. And since Williams Packing, you've been utterly consistent.
Well, even since Williams Packing, there was South Carolina v. Regan, and that case can also be understood as a kind of equitable exception to the rule, which would be inconsistent with thinking that the rule is jurisdictional.
Well, again, I think the best understanding of South Carolina v. Regan is not that it's an equitable exception, but it's the court interpreting a jurisdictional statute as it would interpret any statute in light of its purpose and deciding in that very special case it's a very narrow exception.
Mr. Long, in Bowles, the court looked to the long history of appellate issues as being jurisdictional in its traditional sense, not as a claim processing rule, but as a pure jurisdiction rule, the power of the court to hear a case. From all the questions here, I count at least 4 cases in the court's history where the court has accepted a waiver by the Solicitor General and reached a tax issue. I have at least 3 cases, one of them just mentioned by